Every covered employer under the Family Medical Leave Act is required to make individual determinations about which employees are eligible for FMLA, and the employer's assessment should be fair. And did you know that an employer who intimidates an employee or discourages the employee from requesting FMLA may violate the FMLA law, even though the employer does not deny the request? So let's talk about it. The FMLA prohibits employers from interfering with, restraining, or denying the exercise of or the attempt to exercise any right provided under the law. And you'll find that discussion at 29 U.S.C. 2601 and 2611 to 2620. So let's look at the prima facie elements for making out a case for FMLA interference and what interference looks like. So at the time of the event giving rise to the lawsuit, the plaintiff must show that he or she was eligible. 2, that the defendant was a covered employer under FMLA. 3, that the employee was entitled to take leave under the FMLA. 4, that the employee notified his employer of his intent to take leave. And 5, that the employer interfered with rights the plaintiff was entitled to under the FMLA. So to demonstrate interference, let's look at a case, Ziccarelli versus Dart. And you can find that at 35 4th 1079. It's a 7th Circuit 2022 case. Plaintiff worked as a corrections officer at Cook County Sheriff's Office. He informed his manager of his need to take more FMLA leave. And here's how the manager responded. You've taken serious amounts of FMLA. Don't take any more. If you do so, you will be disciplined. Now, that sounds like intimidation to me, even discouragement. Because of the manager's intimidation, plaintiff became discouraged, and he chose not to take additional FMLA leave, and he ultimately retired a few weeks later. Subsequently, he filed a lawsuit under the Family Medical Leave Act. Plaintiff alleged that the sheriff's office interfered with his exercise of FMLA benefits by discouraging him from taking leave. The district court found in favor of the defendant. The plaintiff appealed. The 7th Circuit Appellate Court reversed the district court. It found that the evidence plaintiff presented was sufficient evidence of discouragement to survive the defendant's motion for summary judgment. The appellate court concluded as follows. It stated, because discouragement is a form of interference, and because interference alone can satisfy Section 2615A1, plaintiff's account of his manager, Shanawi, discouraging him sufficiently supported his claim as to survive summary judgment. Now let me say this, pro se. Keep in mind that this is the Seventh Circuit ruling. A different circuit's opinion may be different. And that's why it's important that, per se, when you conduct research and cite case law, you research it and cite it from the circuit the case is presently filed in. No, it doesn't mean that we never cite cases from other circuits, but there has to be a need for doing it. And I really encourage you to read this case because it will really help you to get a clear understanding of this issue. Okay? Listen, I hope this has been helpful to you. And as always, I am Advocate Lucinda, your empowerment lawyer. And we will see you next time. Take care.